And welcome back to the Law and Crime Network. Let's head straight to the courtroom in the Tex McIver trial out of Atlanta and listen to the testimony of an officer who investigated Tex McIver and his involvement in his wife's killing.
Nope. Okay. Look. Yeah. Okay. Nope. Not yet. Okay. I promise I'll let you know. We're not all going to leave the room and you're just sitting there. We'll let you know. Gary Kane's going to collect a few things and see if there's anything else for you. Thank you.
And the judge is discussing something with the attorneys, so I'm going to discuss something with an attorney who is here with me, Dan Goldman, a former federal prosecutor here in New York. Thanks for joining me. We were talking before about how Tex McIver immediately hired an attorney after he found out that his wife had died, saying, this is not going to look good for me. You said, well, maybe this is related to his background as an attorney. He had the good sense to try to protect himself and not make any statements that could be used against him, whether or not he did this, right, intentionally. But what about the fact that even though he's an attorney, he later made a phone call to his wife's best friend's husband saying, quote, Tommy Lee, this is Tex. Let me be plain. Danny's about to send me to prison. Erase this voicemail, but call me right away. You have no idea the problem this is causing. It's innocent, but it's absolutely nuclear to me. Please, please call me. Does that sound incriminating to you?
Absolutely, and I think perhaps the best evidence that the prosecution has in this trial are Tex McIver's efforts to influence or intimidate or alter witness statements.
But does that surprise you, considering he is an attorney, that he would do something like that?
Yes, it is surprising given that he understood, but you can see from the voicemail, right? It is surprising because he understands the import of it, but you can also see that he is trying to be subtle and cover his tracks, erase the voicemail, call me right away. I'm not going to talk to you about really anything in detail, but I just want to express the urgency of it. Yeah. So he's trying to sort of cut both ways.
Yeah, a little bit frantic and impulsive, but at the same time trying to be careful. Let's toss back to the trial testimony right now of an officer who investigated.
Emory Hospital to Piedmont Park at 14th Street. Were you ever on the expressway?
No. Mr. Hart? No. Okay. You're free to go now. I guess you need to write something down for Ms. Price, but then yes, you're free to go. And ladies and gentlemen, we'll break for lunch now. Mr. Harvey's protestations notwithstanding, we'll keep it to 45 minutes. So if you all could try to be back, please, by 1:30ish, we'll try to get started as close to 1:30. Unless you were planning a special lunch that needed to run late. I'm sure Tony shakes his head and knock it off, Joe. So we'll see you here pretty close to 1:30, and we'll pick up wherever the next witness from the state's going to be. Thank you so much. Let's talk about the case during the lunch break.
All rise for the jurors.
And I'm here again with Dan Goldman. We were just discussing, and let's get back to that discussion about Tex McIver trying to influence witnesses. Now, those were separate charges, but will the jury hear about that, and how will it influence their decision over his guilt in trying to kill his wife, potentially?
Yeah, absolutely, because it's charged. All of that evidence comes in. As a prosecutor, some of the most damning evidence you can have in a case is witness intimidation, because it is such powerful evidence of consciousness of guilt. If you are truly innocent, why would you be reaching out to witnesses to try to get them to change their story or to intimidate them not to testify? And it can be really devastating evidence in most cases. So the fact that they have that evidence is quite powerful evidence for the prosecution.
And we had just mentioned that they did hear about this voicemail that he left his wife's best friend's husband, saying, call me. He says something to the effect, and we didn't have a chance to touch on it before, that it's innocent, but it's absolutely nuclear to me. How does the jury even decipher what that means?
Well, it's hard.
It's so enigmatic, right?
It's hard, and it's not clear cut. And I think it can play both ways into both the prosecution theory of the case and the defense theory of the case. The prosecution will say, of course, that he's trying to cover up whatever it is, that this is what we would call a false exculpatory, that by saying it's innocent, I'm innocent here, that it's actually an intentionally false statement trying to exculpate himself, but really, again, it goes to his consciousness of guilt. That's how it would be raised.
Right.
The defense, though, will say that there's no question here, as there often is, that he pulled the trigger, and that one way or another, he was under the microscope and is going to be scrutinized very carefully.
Right.
So they would say this was just simply a panic mode effort of his to try to figure out what everybody was going to say about him and try to make sure that Danny Jo Carter understood the relevance and the importance of what she was going to say. And that's why he's saying, even though there's an innocent explanation, what she could say to the police and to the prosecutors could be nuclear to him, meaning that
because it could be misinterpreted.
100%. That would be what the defense argument is.
Yeah, and couldn't that also be brought back to the fact that he's an attorney? He understands that statements can be taken out of context, misconstrued by people, and so he wants to make sure that she's not saying anything that would look bad for him.
Absolutely, and he's trying to sort of button up his defense at this point. And I think what is, it cuts both ways. Again, being an attorney, he's obviously going to be aware of the scrutiny that he will be under, but it's also a little suspicious, and the prosecution will harp on this, I'm sure, that he is trying to get his story straight and get everybody's story straight.
But you know what? It even started in the hospital as he's sitting there with his wife's best friend, telling her to say she wasn't even in the car. And she says something to the effect of, what do you mean? How are people going to think that I got here and there's no car and I'm here in the middle of the night? I'm not going to lie. So does the timing of when he starts trying to influence people and what they're saying matter?
It absolutely matters. Again, both sides will have a different gloss on this.
Right, but he's supposed to be grief-stricken, right, at the hospital,
100%.
and he's plotting.
100%, and that the prosecution will really harp on that. That if this was truly an accident, he would not be worried about what his defense is or how it's going to look if Danny Jo Carter is there or what she's going to say. That would be entirely secondary if a spouse died, right? If he really, really cared. On the flip side, the defense is going to argue the guy was in a state of shock. He was in pure panic mode. This is just something that he did as kind of an out-of-body experience. And so I think in that case, the prosecution has the better of the arguments. I think in a lot of the other, as this trial is unfolding, I think on a lot of other issues, the defense may have some of the better of the arguments.
Yeah, well, let's listen to some testimony from Danny Jo Carter, who was the best friend of Diane McIver.
It was at the flag football game, and you went to the flag football game and you were going to confront Tex about certain things, correct?
I had some questions that I wanted to ask him.
And I think one of the questions that you had dealt with what he was going to do about taking care of Austin.
No.
It was, boy, I don't think that Diane would be happy about what?
With the way the will was, like the 2000 will.
Okay, well,
2006 will was laid
had
out.
you seen the 2006 will at that time?
No, I've not.
When you asked that question, did you get information from somebody else about the contents of that will?
Several people had told me that who was in the will, what they were, what was left to whom, and
So-
2006 Austin wasn't born.
I get it. But somebody else had told you about the will.
Yeah, well, I think it was in the news and in the paper.
You hadn't seen it.
No, I knew that that was the one that they got out because Ken Rickard told me the day that they got into the file cabinet.
You hadn't seen it.
I hadn't seen it, no.
You were relying on what other people told you about it, correct?
Yeah, other people that,
Is that, yeah, you can say yes or no.
yes.
Okay. And when a discussion ensued about the will, did I understand that Tex, this will, Tex said that he was revising his will?
He told me in a phone call later that he was revising his will and that he left everything to Austin and nothing to his children.
And when he was revising his will and when he had this conversation with you, he, Tex, invited you, Danny Joe, to come with him.
Yes, he did.
And come with him and come to the lawyer's office when he was revising his will, correct?
Yes.
To make sure that you knew or that you saw that he was in fact revising his will.
Well, I object to the speculation.
That's exactly what he told me.
Well, why don't you ask, did he tell you? As opposed to you. Her impressions we're not so interested in. We're more interested in other things.
And that was Danny Jo Carter, the best friend of Diane McIver, who passed away after her husband, Tex McIver, shot her. He says that it was an accident. I'm here with Dan Goldman, a former federal prosecutor. We hear that the defense is now making Danny Jo tell how Tex, just 2 weeks after his wife passed away, takes her to a lawyer's office to revise his will. We later find out that he leaves his whole ranch, or intends to leave his whole ranch, to their godson because he thinks that's what Diane had wanted, and he sort of wants to please her after she's passed away. He leaves nothing to his own children. His biological children, 3 of them, left with nothing. The fact that he's trying to please her and change the will and bringing this best friend with him to witness that, do you think that was a setup? Or is that something that indicates that he's grieving, but in his own way, trying to make up for what he did to his wife post-mortem?
It is a little suspicious, and it's not only his wife's best friend, it's also the prosecution's star witness, who he realizes is the witness to the accident. So, yes, this is this, from a prosecution standpoint, would be they would argue this is just a cover story. And this is his effort to, after the fact, to undermine the motive that he thinks that the prosecution may be developing, which is that he did this, he killed her for money, essentially, that she had a secret will that was going to cut him out, and that, they apparently did not share money, they had separate finances, and that he basically, he had some insurance policy, that's the rationale of the prosecution. He must know that by this point, and this would be what we would call a cover story to say, oh, that's not at all my motive. Look what I'm doing with my will.
Sure.
The problem is, as you're a parent, I'm a parent, it's very odd to cut your own children out of a will and give everything to a godson. And the prosecution will point out the fact that on the day of the accident at the hospital, he's not worried about her well-being or what she would want. He's worried about covering his own hide. And now, 2 weeks later, all of a sudden, he's so worried about what Diane would have wanted, and it's inconsistent, and that it feels like it's contrived, and that it's created to cover up for his own legal exposure.
Well, there's such a detailed examination throughout this trial of how he grieved and whether or not he was actually grieving. It's such a subjective thing. I mean, you've got people testifying that a doctor wrote that he was tearful, but he wasn't hysterical. If he was calm and collected, the prosecution's making it seem like he didn't care. But he did see a doctor after he was told that she had passed away for anxiety and depression. Right away, he was triaged after he heard the news. Does the fact that maybe he wasn't hysterical, wasn't crying, wasn't panicked in the hospital during the surgery when he got there and right after he found out that she died, does that mean that he did this intentionally, or maybe he just grieves differently from other people?
I agree with you, and I think that if the prosecution is hinging their case on whether and to what extent he was grieving, they have a difficult difficult job.
It seems like that's what they're doing. There's so much focus on what did he say? How was he acting? How many tears did he shed?
Yeah, I mean, look, the fact of the emotional response of Tex McIver and the somewhat flimsy motive about this money, because it wasn't a situation, at least as far as I can tell, where he was destitute and he took out some, as you often see in these cases, he took out, you know, a multi-million-dollar insurance policy a month before and she died. Also, the fact that if he actually wanted to kill her, why would he ever do it with another witness there?
Yes.
That makes no sense. So, you string all of these things together, and the prosecution really does have an uphill battle, I think, to prove that this is malice murder.
Yeah, and another thing that they were focused on was whether he had told any of the doctors or nurses at the hospital about his sleep disorder when he was being treated for his anxiety and his depression, and the fact that he omitted that from his medical history. The prosecution's trying to say supports the fact that maybe he didn't really have a legitimate sleep disorder. But Danny Jo Carter testified that she had heard of the sleep disorder, which he claims suddenly woke him up as he was holding a gun in the backseat of a car and caused the gun to go off as he just jerked out of this sleep because of his sleep disorder. So let's listen to her testimony about that.
You knew that Tex had a sleep disorder.
Yes.
And you knew that he had a sleep disorder where when he woke up he couldn't distinguish between his dreams and reality.
That's what he told me.
Yes. And you know that he had this sleep disorder in September of 2016, correct? Correct?
Yes. Yes.
And that when he awoke,
You guess.
I don't know anything. I'm not a sleep disorder. I don't know once you have it if they go away.
you understood that when he woke up or when he was asleep, he would lash out, correct?
That was.
And in fact,
Did you finish your answer?
I'm sorry.
Right. You keep answering. He doesn't get to cut you off.
Yeah, and I'm sorry. I apologize. He would lash out.
Yes.
And you understood that Diane was afraid he was going to hit her.
Yes.
So Danny Jo Carter admitting that she did know about this supposed sleep disorder where Tex McIver would wake up and sort of be out of his comfort zone and reactive when he would wake out of the sleep disorder. Does that make his story more believable? The fact that he asked for this gun and then he falls asleep holding it. It's in a plastic bag, which is bizarre as well. Because if you want to fire a gun, why do you leave it in a plastic bag? Perhaps to show that your fingerprints weren't on it, but he doesn't contest the fact that he was the one that fired it. So he's got it in a plastic bag in his lap. He claims he falls asleep. He awakes with this paranoia in his head that he's in a bad area, and all of a sudden the sleep disorder, he said, causes the gun to fire. Have you ever in your years as a prosecutor heard a story that outlandish?
This is a new one for me, but it's very, very important testimony for the defense that Danny Jo Carter can corroborate the testimony or the story, so to speak, of Tex McIver, that this is about a sleep disorder and that he has the sleep disorder, which is consistent with what he did tell the police afterwards. So the fact that she agrees with that and that she knew about it beforehand is very helpful testimony for the defense.
Here's the problem, though. He doesn't just talk about his sleep disorder. He also says to Danny Jo Carter that they hit a bump and that's what caused the gun to go off. So he's got a lot of different competing stories.
Right. I mean, it's all a variation of the same thing. He hit a bump, and I think
And that's what woke him, you're saying, out of the sleep
the bump
disorder.
woke him, and then
Right.
that's what he jerked because he has this disorder where he will lash out, or he doesn't know whether he's in a dream or reality or whatever it is. But it's on the one hand, if he has multiple stories, that's a problem. But on the other hand, it's all a variation of the same sort of story here.
Yeah, it's just that the prosecution's going to try to paint it as different stories to show inconsistency, and the defense is going to say, no, these are all related. He just didn't know how to communicate it. Let's toss now to a quick commercial break, and we'll be back to give some more in-depth analysis on this trial. Tex McIver out of Atlanta. And welcome back to the Law and Crime Network. I'm your host, Amy Dash, and I'm here with Dan Goldman, who's a former federal prosecutor. I want to try to have you put yourself in the defense's shoes. You've never been a criminal defense attorney, correct?
That's right.
So how would you defend Tex
I play
McIver?
one on TV.
Oh, okay. Right now. Well, right now you will be playing one.
Right.
So how would you defend him in this case? What would be your strategy?
My strategy would be to hammer reasonable doubt. I think this is a clear-cut reasonable doubt case where the facts are not in dispute. In a lot of murder trials, you will have identity as a dispute. You will have disputed whether who the shooter was or what the circumstances were. This trial is interesting because there really are very few disputed facts. Everybody agrees that he was in the backseat of the car, he shot the gun, it hit her in the front seat, they drove to the hospital, etc. So there are very few facts in dispute. What is really in dispute here is intent. And it's whether he intended to shoot the gun or whether it went off accidentally. That's the only issue here. And so if I'm the defense, I am absolutely hammering the high burden of proof of reasonable doubt to say that look, there may be things that are suspicious here. His reaction might be suspicious. The financial motives may have some suspicion. But at the end of the day, you do not have enough evidence here to show beyond a reasonable doubt that he actually intended to kill his wife. And I think they've got a lot to work with because you've got the financial motive is not clear-cut. And then you've got a lot of just sort of human error, human nature, emotional reactions. And it's without a statement or a recording or an email or some sort of corroborating evidence to show that this was his motive. This is really a circumstantial case. You're trying to pull things together here and there and put it all together. But for the witness intimidation and those charges and also, more importantly, the facts underlying them, which will come in as evidence because they're charged. But for that, I would say there's absolutely no shot. That evidence is very helpful to the prosecution because they can argue that if this were truly an accident, why on earth would he be trying to get everyone's story straight and trying to speak to the witnesses? Why would he not just recognize, like, there's nothing, I don't have anything to worry about here?
Well, and what they're doing is they're painting this interference of his in the gathering of evidence and the future testimony of witnesses as basically as a cover-up of sorts.
Absolutely, and it is. And I mean, it is quintessential consciousness of guilt evidence that particularly someone like him who's a lawyer, should understand. On the flip side, we can't live in this myopic universe where we think that law enforcement gives everybody the benefit of the doubt. And I think that from his perspective, if I'm the defense attorney, I'm saying, look, the bottom line is that there are inferences that can go either way, and he understands how things are, but he can't control how the police think about it, how the prosecutor thinks about it. So he's trying to get a sense and trying to understand what other people are thinking. And frankly, he's close with Danny Jo Carter and Danny Jo Carter's husband. So they're friends. It's not crazy that they would be talking about this, but for the fact that he's accused with killing.
And but for the fact that he probably assumed their loyalty and friendship, and then they went and testified and pretty much gave him up as to the things that he was saying to them behind the scenes.
Right. I mean, he should also know they have no choice. This is not. It's not a loyalty oath, as we've been hearing in the news. This is you're obligated to tell the truth and to tell everything you know. Or
they could have faced some sort of penalty. So that may have been motivated by fear.
Absolutely. I mean, they are obligated to tell the truth. If they do not tell the truth, they can be charged with a crime.
Right.
So it's a significant obligation when you're a witness to an investigation.
Yeah, but as we were discussing, the jury has to make so many logical leaps to take these subjective and pretty confusing, really not clear-cut statements, piece them all together, and assume that the killing was intentional because of the things he did and said afterward. There's really not a lot leading up to the actual shooting that can indicate that there was some sort of planning that would support intent.
That's right. I mean, that's not so unusual. You are often tracing things back after an event, a sporadic event such as a murder happens. But you are correct, right? If there's a murder for hire or if there's an intentional, premeditated murder by a gang, by a group, whatever it is, there are going to be discussions about it, and oftentimes you'll see in those cases there'll be cooperating witnesses who will testify and say, yeah, I had a conversation where we discussed doing this and we went about and did it.
And that's perhaps stronger if you have the evidence leading up to than after the fact, unless the after the fact cover-up involves dumping a body or something like that. But here you're taking statements and you're scrutinizing them. For example, Diane McIver is dying in the hospital after her husband just shot her. The doctor says, would you like to see your husband as you're dying? She says no. Well, maybe she didn't want to see him because he just shot her. It doesn't mean that she doesn't want to see him because she thinks that he did it on purpose. But it could mean that, too. So what they're doing is they're sitting there making the jury really try to do a lot of guesswork here when the essence of reasonable doubt is if you don't know and it could go either way, then you sort of have to err on the side of the defendant.
That's exactly right. You hit the nail on the head. And I think the other thing that the defense really would gets a lot of mileage from and a lot of traction from is the fact that Danny Jo Carter was driving the car. It just doesn't make any sense that if he wanted to kill her, that he would have done it in this way and under these circumstances. And I think that any jury would understand that. And so it's interesting. I mean, there is always the compromise verdict, and from a prosecutor standpoint, sometimes you may charge a little more aggressively if you have a lesser charge that you think the jury might vote on, because there's a lot of horse trading when jury deliberations, and maybe you think, you know what, we think there's more to this than just simple involuntary manslaughter. But if we don't meet our burden, the jury can still fall back on involuntary manslaughter. Which
he could still be convicted on those lesser charges.
Right.
Right, because the judge can always include them in the jury instruction phase.
Correct.
We're in a clip right now. We're watching as Tex McIver pulls up to the hospital. You can see he's in the red shirt now. His wife has just been put onto a wheelchair. She's slumped down, and she can't lift her legs. She was described as flaccid when she arrived and totally unresponsive. I think her blood pressure didn't even register. That's how low it was. Now, this was also scrutinized. The fact that he's holding her leg up for her, the fact that he is trying to communicate with her, trying to assist and get her help, and even the fact that, listen, they drove right to the hospital after this happened. Does that help him? Or, I mean, could it just easily be painted the other way and say, well, he knew that there was no way she was going to make it, so this is all to just try to show that he didn't mean to shoot her?
This is the unusual circumstances, as you pointed out, Amy, where every single statement, every single move, every single moment after the shooting has to be scrutinized so carefully, because it's a retrospective charge in the sense of you're looking at what happened after to try to figure out what was in his mind at the time. And that's a very difficult thing to do. So ordinarily, you would say, yeah, that's not that big a deal. It could go either way. He could have intended to do it but want to paint it as if he didn't intend to do it. Or it could be truly an accident, in which case he would be acting that way legitimately.
Right.
But again, it's going to break down with a reasonable doubt. If there are two competing and equally plausible philosophies or theories, then you got to go with the defendant. And certainly as you watch those pictures on there, he is trying to help. He is absolutely trying to get her to the hospital and help them. I don't quite understand why they didn't have a stretcher at a hospital, but
yeah,
in any event, he is
point.
trying to help get her the care that she needs and get her to the surgery and hopefully, you know, in order to save her. I mean, the other thing, by the way, if he were really truly trying to kill her, why would he not shoot her in the head?
Yeah.
You know, why is he going to shoot her in the body?
Right.
So there's a lot of reasonable doubt that jumps out at me about this case.
Yeah, and we were expecting to hear some pretty damning testimony from Danny Jo Carter. I mean, she was the one that I was really excited to hear from because she's sitting there. She's the eyewitness. She knows exactly what happened. But it doesn't seem like a lot happened in that car until the shooting, and all of a sudden it caught everybody by surprise, unless Tex intended it, and then he wasn't caught by surprise. But he even says to his wife, "Darling, can you pass me the gun?" It's like, who calls somebody that they're about to shoot darling? Just to give him the benefit of the doubt. Unless he really is this evil plot machine who is setting everything up to a T, but then why is he panicking afterwards and continuing to try to change the story of people? Wouldn't he have those ducks in a row as well if he was literally going to address his wife with endearing statements before he shoots and kills her?
The circumstances are unusual, and you could have a reading of his conversations with Danny Jo Carter where he's actually just looking out for Danny Jo Carter. That he recognizes that this is a horrible accident gone wrong, and she's now implicated in it because she was a witness to it and she was there, and that his immediate efforts right in the hospital to try to help her get out of it are not to protect himself, but really to protect Danny Jo Carter. So again,
though I find that to be a little bit harder to believe, because if you're thinking about the statements that he said about how it didn't look good for him, he's running to hire an attorney. Certainly that's a possibility, but it seems more likely that he's trying to cover his own hide.
I agree with you. I agree with you. The only point I'm making in saying all this is that there are so many different theories here.
But you can paint it so many different ways.
How is a jury going to sit there and say, I find beyond a reasonable doubt, which is not any doubt, but is a much higher standard than a 51-49, I find beyond a reasonable doubt that this guy intended to kill his wife and he's going to go to jail for the rest of his life.
Yeah.
That's a very big responsibility for a jury. And when you start to have, and you're quibbling over, well, this could mean this and this could mean that, and there's nothing direct, there's nothing concrete, there's nothing really devastating. There's certainly no smoking gun. You don't always need a smoking gun, but when you have such a
except for the one that was
case,
fired.
Yes, exactly. But again, in this case, the fact of him firing it and his fingerprints on it, which often is how these murder cases are solved, it's not relevant here because there's no dispute that he shot the gun. So this is the unusual case where, you know, the gun doesn't matter.
Sounds like a quirky guy. Why hasn't the defense brought in experts to try to establish that he had these paranoia issues that may have led him to think, oh, we're in a bad area, I got to get my gun for self-defense, and sort of be overreactive to a situation? That he had some sort of mental issues going on that may have led him to be so scared that this accident was plausible, but for a reasonable person may not have been.
So a couple of things. First, we're not at the defense case yet, so it is still possible that they could do that. But what a good defense lawyer would try to do is to make his or her case through the prosecution's case. Because if you're able to say, and in a case like this, I think they would want that you could say, we don't need any witnesses because you've heard, their witnesses are our witnesses. And their witnesses have demonstrated to you that there is no guilt beyond a reasonable doubt. We don't need to bring in anybody to tell you that he had the sleep disorder because Danny Jo Carter told you that he has the sleep disorder. And ordinarily, a battle of the experts is to the defense's benefit. But I think in this case, they don't want to get into a battle of experts where it's this expert versus that expert, because I think they'd rather just make the case through the prosecution's case and be able to say, We don't have any witnesses, Your Honor, and to the jury, we don't have any witnesses. We don't need any witnesses. That we've clearly demonstrated through their case that there is no reasonable doubt, beyond a reasonable doubt here, and we don't need to do anything.
Well, it sounds like what you're saying is that for them to put on an exhaustive defense would seem defensive, and therefore could undercut his claim that really there's no credence to the arguments of the prosecution, there's no substance to what the prosecution's witnesses are saying. But on the other hand, taking your approach and going in there and saying, well, I don't have to do anything because everything you just heard is ridiculous, sounds very risky to me as well.
It is risky, and there are a number of cases where big federal cases that at least I'm familiar with that have been significant, where the defense has taken that risk, and that, as a defense lawyer, you better win. If you don't bring a case of your own and you have a plausible case and you're really going to rely on reasonable doubt, then you better win. But if you are relying on reasonable doubt, you often don't need your own case, because it really is an argument that the prosecution has not met its burden, and by putting on your own case, you're getting away from that argument, because you're saying that if you're trying to say the prosecution hasn't met its burden, and you know that because I've put on witnesses to show you that, well, that's a different calculus.
Yeah, because you're giving validity to their witnesses rather than saying that their witnesses aren't really giving any information that could prove intent.
Well, you're undermining your own argument that they haven't proven their case beyond a reasonable doubt, because you're now bringing in your own witnesses to dispute their case.
Yes.
And so you're much better off going through cross-examination to try to undermine their case rather than your own witnesses. And frankly, that is how good defense lawyers do it, and they try to turn prosecution witnesses into defense witnesses, and I think that the defense lawyer did that with Danny Joe Carter as to the sleep disorder. I think that's a very powerful statement by Danny Joe Carter in favor of the defense, and it's much better when you get the other side's witness to say something that is favorable to you.
Sure, because you're discrediting them in a respect. You know, it's like sort of like they're going down the line, like boom, 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 trying to knock everybody out. I mean, you saw it with the nurse. There was a nurse, Sullivan, who seemed like a prosecution witness, but then on cross, it sounded like she was really had a bias against Tex McIver, because she said something to the effect of, to the DA's office, like, I hope you get this guy, or something like that. So it assumed that she felt that he was guilty, because she overheard some statement that he said, you know, like, what are we going to tell them? Something very obscure.
That is the sort of defense attorney 101. You want to demonstrate either that a witness is not credible or that a witness has bias. And that not only does that undermine that witness's testimony, but it also it has a spillover effect on the entire prosecution case. Because the argument then is, well, if the DA is going to put a witness on with that much bias, then the DA has some bias too. And you not only can't trust that witness, but you can't trust any of the witness that the prosecutors put on. And that can be a very effective method of defense.
Certainly. Let's listen right now to some testimony. It's a clip, actually, of Tex McIver's voicemail to Danny Joe Carter, his wife's best friend, who was in the car at the time that she was shot, to her husband. And he's probably trying to do something to influence this husband's testimony. Take a listen and see what you think.
And can you tell the jury were any voicemail messages left in the phone calls you received from the defendant?
Yes.
Okay. Did you check those voicemail messages?
Yes.
And did you recognize the voice in the voicemail messages?
Yes.
Who did the voice belong to?
Tex.
Now, after you listened to the voicemail message, can you tell the jury what did you do with the message?
I deleted it.
Okay. Early last year, you were kind enough to invite me to your home where I had a chance to speak to you.
Yes.
At that time, can you tell the jurors, did you share with me the circumstances surrounding this deleted voicemail message?
Yes.
And did I send someone out to your house in connection with this deleted voicemail message?
Yes.
Who did I send?
It's Adam.
Mr. Adam Abadi.
That's right.
And when Mr. Abadi came to your home, what did he do?
He was able to retrieve the message.
I believe it's text. Sir, let me just be plain. Danny's about to send me to prison. Please erase this voicemail message, but call me right away. Y'all have no idea the problem this is causing. It's innocent, but it's absolutely ridiculous for me. Please call me.
Oh boy, does he regret that by now, right?
For sure. I think he's he'd much rather prefer that not be played in court at his murder trial.
Especially since he implored them to delete it.
Absolutely. It goes to consciousness of guilt, right? You're reaching out to witnesses saying, Danny Joe's about to send me to prison. Now, again, the defense has some wiggle room here because I think there's an argument to be made that sort of in an unwitting way, Danny Joe is going to send him to prison because
I thought that
they're
too.
spinning that his argument would be, I'm innocent. Mm-hmm. It's innocent, but the prosecution is taking Danny Joe's testimony and turning it on its head to frame me or implicate me in a broader motive than I have.
Yeah, it was focused on that statement too because he's not saying anything about his own actions sending him to prison. He's not trying to over-explain that it was an accident. He's simply focusing on the words that she's using.
Right. But on the flip side, he has to recognize that, as a lawyer in particular, that she's a witness and she's got to tell the truth and she's going to say whatever it is that she remembers, and he can't control that. Yeah. So by making this voicemail call and calling Danny Joe's husband, he is trying to coerce her, you could argue, certainly the prosecution will argue, coerce her into not testifying or perhaps to change her story. Whatever it is, because whether it's to not testify or to change her story, it's to do something different because whatever she's doing, he believes is going to send him to prison.
Right.
And so,
but he's doing something illegal in the process of trying to protect himself.
Absolutely. But and yes, I think, look, from Tex McIver's standpoint, if he were convicted of witness tampering and acquitted of malice murder, he would take that.
Yeah, for sure.
This is, and I think that generally from the prosecution standpoint, certainly you want to, from the standpoint of trying to preserve the criminal justice system and how it should operate, you want to make this charge and you want to make sure that people do not do that and that there's a deterrent effect for that. But there's a real evidentiary benefit to it because otherwise this evidence may not come in, but because you charge it, it has to come in.
Yeah.
And so that's a real benefit to the prosecution. But just going back to the actual voicemail, there's no good explanation for Tex McIver on this because either way, however you want to construe it and however the defense will construe it, he's trying to get her to do something different than what she's doing. And the only reason that he would try to get her to do something different is that because whatever she is doing is going to implicate him.
Absolutely. Let's toss to a quick commercial break. We'll talk back with Dan Goldman about whether he's going to take the stand and whether he should.
The second week of testimony in the Tex McIver murder trial is underway. The defendant, himself an attorney, says when the gun went off, it was accidental. The victim's friend, Danny Jo Carter, was behind the wheel when the victim was shot. She testified that the defendant was concerned over the route they took that night.
As we were exiting and we were on the off-ramp, he said, "Girls, I wish you hadn't have done this. This is a really bad area. You should have just stayed on 85.
Carter testified Tex McIver asked his wife for his gun. She gave it to him. Prosecutors suggested there was no need for the gun to be out, and Carter agreed.
They were sitting on the sidewalk. It was on the left side of the street, and they were kind of gathered around, and there were cardboard boxes out there, and it just looked more like a social gathering than people that were going somewhere.
Did that group of people approach the car at any time?
No, they did not.
Okay. Did you see anyone who appeared to be protesting anything out there?
No, I did not.
When they pulled up to a red light, tragedy struck.
I heard a big boom, and I didn't know what it was. I thought there was an explosion somewhere, and my head turned to the right, and I looked out the window and wondered where there was an explosion or if somebody behind us was getting ready to hit us or something had happened behind us. I did not realize that it was a gunshot.
Carter described the panic following the shooting, but the defendant's demeanor was contained, even though he had just shot his wife.
Could you describe then what was his demeanor like?
Kind of he was holding her head and saying, Diane, Diane, but, contained.
What do you mean by contained?
Not screaming or yelling or hysterical or anything.
Carter testified the defendant advised her to be careful and was giving her directions to the hospital.
I just asked him where the closest emergency room was.
And what did he say?
He said, Emory, we should go to Emory. And I said, you're going to have to tell me how to go, which way to get there, because I don't know.
And as you were driving this route, who was telling you which way to go?
Tex was.
Carter says Tex McIver told her to lie while they were sitting in the hospital.
Anything else?
You just need to say you came down here as a friend of the family. I said, Tex, I just drove you into the emergency room.
And then did he say something in response to that?
He looked at me and he says, well, they don't know that.
Carter recalled a meeting with McIver where he asked her to tell him what she recalled about the shooting.
We sat in these two chairs and he asked me to tell him what my recollection was of that evening that Diane died.
And can you tell the jurors, when you were sharing your recollections with the defendant about what happened that evening, what was he doing?
He got out a pad and paper, legal pad, and started writing. After he wrote a couple of paragraphs, I leaned over and I said, Tex, those are my memories. You just need your memories. And I got up and walked out.
Prosecutors say Tex McIver shot and killed his wife for financial reasons. And the friend you just heard testify talked about her plans to change her will. She said Tex McIver canceled those appointments, but we'll have to see where things go on cross-examination. This is Aaron Keller for the Law and Crime Network.
Welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with former federal prosecutor Dan Goldman. You had mentioned as we were watching that package that Danny Jo Carter, when she took the stand, did say something in favor of Tex McIver's case, and that is, she said something to the effect of not to get off at a certain area because he felt that it was a bad area to potentially stay on the highway.
Well, it's an explanation from the witness why he got the gun. And again, if this were an intentional murder, he would not have needed an excuse, so to speak, to get a gun. But because they were going into an area that he felt like was dangerous for whatever reason, and they got off the highway and they should have stayed on 95, that his argument is, it corroborates what he's saying, which is, I asked for the gun from my darling, as he said, his wife, because I was nervous about the area we were going through, not so that I could kill her.
Right.
So it
supports
undermines,
his fear.
Right.
The fear that he's saying was underlying his shooting her, his accidental shooting.
Right, and it undermines the motive.
Right.
It undermines the prosecution's argument that this was intentional, and it sort of backs up his story and not the prosecution's story.
And we can see the judge has taken the bench. Really quick question. Should and does Tex McIver take the stand in his own defense in a case like this, given everything we've heard and seen so far?
It's a very tough call. Ordinarily, I would say the defendant should not take the stand.
Well, that's certainly the default, right? But again, if you have nothing to hide, if you truly are innocent, does it look bad not to take the stand?
I think so. Part of it, again, if there's any defense case, and I think that they could make the calculus to say, The prosecution has not met its burden. We do not need to put on any witnesses. But if there is any defense case, I think he's got to testify because the facts aren't in dispute. It's all about what's in his own head. And at the end of the day, the jury wants to hear from him what it's about. The problem is, basically, the whole prosecution case goes out the window when the defendant testifies. Then it just becomes a question of whether the jury believes the defendant or not. And
we've heard already that he's not a guy that shows a lot of emotion. Could that backfire on him if he doesn't get emotional? Because at the beginning of this trial, he did get emotional. Maybe after hearing all the testimony about how unemotional he was at the hospital, maybe he's going to be overly emotional on the stand if he takes it, and that could go in his favor.
Every single move he makes, every single breath he takes will be scrutinized by the jury.
That sounds like lyrics to a romance song, is it? I think you just pulled that from a popular artist, but I can't come to mind as to who.
I wish I were that good, but
every
I'm
move
certainly
he makes,
not.
every breath he takes.
Yeah,
That's
exactly.
like Celine Dion or something like that.
Maybe the police. He will be really, really scrutinized, and the problem with the defendant testifying is just that. Because it's not about what he said at the time, it's not about what he did, it's not about what any of the witnesses say, it's just whether or not the jury believes him. But for the fact that he has these charges of witness tampering and that will be a strong subject of cross-examination for the prosecution, I would say he should testify if there's a defense case. Again, I think they have what I would do if I were them right now is I would say, we have no case. We're not putting them, and I would just hammer reasonable doubt. But if they're going to put on a case of any sort,
put him on the stand.
I think they need to put him on.
All right, let's head right back to court now and hear what the judge is saying.